there was another decision yesterday, another ruling that we thought was interesting. Put this next one up on the screen. So the Supreme Court said that a conviction for online threats violated the First Amendment. This is a write-up in the Washington Post. The subhead here says prosecutors have to show that a person responsible for threats understood the threatening nature of that speech. So the backstory here, as I understand it, is you had a music artist who was being stalked effectively by this dude who kept sending all these threatening messages. She said it really impacted her. She was scared for her health and safety. She, for a time, stopped doing public appearances and public concerts, so it impacted her career because she just never knew whether this guy was going to turn up and what he might be capable of doing, et cetera. And so the question here was whether or not you could uphold this conviction for these online threats. And let me give you a taste of what she was being sent here. And she would block his account on Facebook, and then he'd create a new account and still post these messages, et cetera. So among the messages that were presented at trial, there was one that said, "I'm currently unsupervised. I know it freaks me out too, but the possibilities are endless." So listen, no one wants to get that message. That sounds really creepy, but it, to me, doesn't meet the test of like a direct and specific threat.
Right.
Another one said, "F off permanently." Another one said, "You're not being good for human relations. Die, don't need you." What the majority decided here in a 7-2 ruling, with Elena Kagan writing for the majority, and I'm reading from the Washington Post now, the court emphasized that true threats of violence are not protected by the First Amendment, of course, but to guard against a chilling effect on non-threatening speech, the majority said states have to prove that a criminal defendant has consciously disregarded a substantial risk that his communications would be viewed as threatening violence. So it's not enough that it is a violent threat, which is not protected by the First Amendment. There also has to be an intentionality around it, or a reckless disregard, as I'm not sure that's the exact language that they use, but that's effectively what they're communicating here. But that there needs to be some sort of understanding of the way that these threats would ultimately be perceived. You had Justice Clarence Thomas and Amy Coney Barrett who wrote who were in the dissent. Barrett wrote that the standard set by the court on Thursday gives, quote, "preferential treatment to a broad range of threatening speech and makes it more difficult for law enforcement to address actual threats." A little bit more from Elena Kagan. She says, "Our decisions have often insisted on protecting even some historically unprotected speech through the adoption of a subjective mental state element." This is writing for the majority. "We follow the same path today, holding the state must prove in true threats cases that the defendant had some understanding of his statement's threatening character." What do you think of this one?
And, you know, that's very different than saying, you know, to your point, which I think is a good one, whether or not this particular speech met the threshold, whether or not someone knew it as a threat. I think that's probably the more interesting question with those messages.
Right.
It's like, is especially now that we live in this online world where people almost feel like they're seduced into thinking they're playing a video game when they're talking to real human beings on the other side because of the way social media functions. I think it's a really interesting question of whether speech where you say die and then, you know, but it's not really like I'm going to kill you, die, constitutes a threat. Like, that's to me a more interesting question than whether he knew it was a threat, because I actually kind of tend to side with Barrett. And one of the things we should say, like these last two decisions we've been talking about, 6-3 and 7-2. So
they were not just partisan down-the-line votes. Yeah.
Right, yeah, exactly. So you have Justice Roberts writing in the 6-3 decision, and you have just Amy Coney Barrett and Sotomayor and Gorsuch coming together in that ruling. Like, that's a beautiful the start of a beautiful matchup. Friendship. Yeah. But I think in this case, I'm sort of tempted to be with Amy Coney Barrett on that, because I can envision, especially for people that are mentally ill, a whole lot of threatening speech now not being or being protected in ways that it absolutely shouldn't be, because you can make the argument with a good attorney that, hey, this person didn't know. You know, they didn't understand this to be threatening because they lacked the capacity at that particular time.
I think that's a fair point. I mean, it's undeniably, like, it's a subjective judgment. So if you can hire if you're wealthy, you can hire a great attorney.
Right.
They can convince a jury that they didn't even know what they were doing, right? They had no idea the way that this would be perceived as so threatening. Then you potentially, allow an avenue for people to get off the hook for things that really should not be accepted. I tend to go in the other direction, though, just because, I think the First Amendment rights are so foundational that I would always err on the side of protecting them more and have more concern about, a potentially chilling effect of non-threatening speech if you do not have these sorts of bounds in place. So I tend to err more on the side of, all right, let's err on the side of free speech. But, I think the concerns voiced in the dissent are completely legitimate. Like, where are the boundaries here? How do you even interpret somebody's subjective intent or what was going on in their mind? But in some ways, that's the nature of a lot of our laws turn on determining someone's mental state and their intent at the time that a crime was committed.
And also, this is how you met Kyle.
Well, in case you don't know, Shu actually documented this, that I was the first one to reach out to him. So
funny.
If anything, it goes in the other direction.
That's one of my
me
favorite,
being the harasser.
One of my favorite viral tweets ever. It's like, ladies, don't be afraid to make the first move, and it's
right,
Krystal sliding into
Go
Kyle's
for
DMs. But I would argue that you didn't know that was a threat at the time.
I didn't, yeah. So I agree with the majority here. I don't think it should be considered that way because I was, out of my mind. I had no idea what I was doing and getting myself into, clearly. So we are expecting, make a hard turn here, we are expecting some other really momentous decisions here. And listen, as much as we expect these are going to go one way or the other, you just never know, right? The justices have already proven themselves to be somewhat unpredictable. So put this last piece up on the screen. Supreme Court's biggest decisions are coming. Some of these I think could come down today, tomorrow, and I think, Emily, that this is the last week when we are going to get rulings from the court. So all of these are still hanging out there. Big one, affirmative action. Yeah. This is, per the AP, the survival of affirmative action in higher education, subject of two related cases, one involving Harvard, the other University of North Carolina. Supreme Court has previously approved of the use of affirmative action in higher education decisions reaching back to 1978, but the justices' decision to take the cases suggested a willingness to revisit those rulings. So obviously that's a big one. We're already planning a panel for tomorrow, which, by the way, it's going to be me and Emily again tomorrow for Breaking Points, because Sagar, as you guys know, is away for his first of two wedding ceremonies. So we're planning some coverage of that whenever that decision comes down. They also have on the docket student loans. Are they going to uphold President Biden's plan to reduce student loan debt that has been, highly contested? There is a potential that the justices decide the challengers lack the right to sue, that they don't have standing, and therefore the plan can still go forward. I think that's the best hope for those who are hoping that student loan debt relief remains in place. And the challenge with that one is basically like, okay, well, who is actually harmed by this decision? And conservatives have had a hard time coming up with a group that was, legitimately harmed. They went with, I believe that this case relates to a student loan processor that says like, our fees are being cut and we're being hurt by this decision. But that's a possibility that they could just sort of like punt on this one and say, listen, they don't have standing, so we're not issuing really a ruling at all. Another one here is on gay rights and religious rights and the, where's the line here? This one involves a graphic artist in Colorado who is Christian, who wants to design wedding websites but does not want to design same-sex wedding websites. This has, the gay cake baking thing, very similar kind of dynamics here.
Yeah, I've talked to her. It's basically the exact same thing as Masterpiece and the Washington Flower Shop with Bernal Stutzman.
Sagar and I were trying to remember, has this not already been, didn't they already rule on those? What happened there?
Yes, but it's so state-based. So if your state has a very particular law that can then get sort of stress test intentionally, and in the case of Jack Phillips with Masterpiece Cake, you had LGBT activists intentionally stress testing the laws and making sure that these were cases that were ready for the court, basically. This is sort of similar in that it's preemptive, that Lori Smith of 303 Creative, who wants to design websites, wants basically the state. She doesn't think the state law protects her right to refuse to make wedding websites for gay couples, a gay wedding. And so it's similar in the sense that it's kind of a preemptive thing where it's going to court and it's kind of intentionally stress testing.
Got you. So seeing where exactly the bounds of this candidates are.
Right.
Okay. All right. So those are some of the big ones that we're watching for. Obviously, all of these would be extremely momentous, and we'll be all over it. And like I said before, we're trying to get together some experts on both sides of the affirmative action debate so that we can kind of like get into that one tomorrow on Breaking Point. So make sure you stay tuned for that. Hey guys, if you like that video, go to breakingpoints.com, become a premium subscriber, and help us build the best independent media organization on the planet.
That's right. We're subscriber funded. We're building something new. We want to replace these failing mainstream media organizations.
So again, to subscribe, it's breakingpoints.com.